Welcome to InFringe at Your Own Risk.
Welcome to InFringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. I'm Lisa Mosbey, and today we're talking about joint inventorship. Rand will cover how the law determines who qualifies as an inventor and what can happen when someone is mistakenly left off a patent application. Rand, welcome to the show. This sounds kind of complicated. Are you ready to get into it with me today?
This gets really complicated, yes, but it's fun looking at the different aspects of it.
I know it's your wheelhouse, and I want to know how patent law defines who legally qualifies as an inventor.
Under the patent laws, the inventor is the person who provided the inventive concept. Okay, it's not necessarily the person who actually implemented it. So if I sit down on a whiteboard and say, here's my invention, I chart it out, but in the process of applying what I wrote out on the board, the technician says, you know what, this way that Rand's doing it works, but I think it'll work better if we do it this other way. Okay, then the technician may become an inventor. And so to do a proper inventorship analysis, you go through the claims of the patent and say, okay, who came up with this claim? And you look at claim 1 and they say, oh, well, Rand came up with that. Yeah, that's clearly his idea. But when you get to claim 6 and they say, well, what if we use this instead of that? In claim 6, you would have to say, well, the technician is the inventor of that claim, so he is now a joint inventor on the patent. If somebody invents any claim or is an inventor of any claim in the patent, they need to be listed on the patent. And, you know, this gets discussed hypothetically a lot. For many years it has. In the old days, inventorship was a really big deal. And so they resolved that by saying, okay, well, you can correct inventorship. Even during litigation, you can correct inventorship. And then a couple episodes ago, we talked about the Fortress Iron versus Digger Specialties case. And in that case, the company created an invention. They had outside help from a Chinese company that they were working with. And in the analysis, it turned out that some of the claims were invented by employees of the Chinese company, and they were left off the patent. Well, normally you would then have a hearing. The people who were left off the patent have the right to attend the hearing, and you would say, okay, well, we're going to add Mr. Lee and Mr. Wong are going to be inventors on here. The only problem was those employees had left the Chinese company and could not be found. And because of that, you could not meet the requirements to do a correction of inventorship, so the patents were held invalid.
Oh,
so
no.
Every patent attorney's nightmare actually played out. And so it's important when you're doing your invention to say who created this and go through the claims. Who was an inventor? Who wasn't an inventor? And, you know, I've had times where people were being gracious and just said, no, I'm not really an inventor. And then some of the other inventors came to me and said, he was definitely an inventor. He needs to be on there. And that's important. The joke used to be when you get like a Russian patent, if you ever see one, the last named person is the inventor. And the person just before him is his supervisor. And the person before him is supervisor. It goes all the way up the chain to the first named inventor. Is like 5 levels up of supervision. And that's not supposed to happen. And occasionally you'll see a company where the president of the company is on every single patent. And then you start thinking, you know, is that real? And there are some people like that. I've dealt with some geniuses who literally they're involved, even though they're the CEO, they're involved in everything. But I've also seen a lot where you're pretty sure, you know, he's a mechanical engineer and the invention's in this really complex software. Probably not. So that's an issue. If you're falsely naming people, it can result in a invalid patent. So it's important to get it right. But it's analysis of the claims. When you read the claim, who invented that? And it was, Susan and Jim. Okay, so Susan and Jim are inventors, but you need to go through each claim, because if any one claim has somebody else, that person needs to be listed on the patent. So that's one of the nice things with the US, though, is it gives credit to the inventors. There's some places where it's really the company gets more of the credit than the inventors. So, but yeah, that's how the analysis is done.
Two things come to mind with that description is inventor versus someone who simply executed or tested the product. I think could get kind of muddy, because the person who's executing or testing, they're in there, they're doing it, they're maybe tweaking things. They're not part of the inventor list, correct?
And yes, and sometimes people get offended because they're like, well, I was involved in this. Well, you were, but you didn't invent anything. You just implemented what they invented. So, that's an issue. But the flip side's also the same, where sometimes people really were inventors and they're getting left off because, somebody's ego, no, this was my invention. So it's a challenge. And, sometimes if you're concerned as the patent attorney, you have to kind of dig a little deeper and, okay, so no, you came up with this part, you came up with this part, and oh no, that was actually Susan that did that. Okay, well then Susan needs to be an inventor on this patent.
And that was my other part of that question is inventor versus execution or testing personnel. And then the other one is how does the analysis change when an engineer refines or improves an existing idea rather than originating it? Are they part of the invention team?
It depends what the improvement is, right? If the improvement is spelled out in the claims, then yes, they're part of the invention the team. If it's not, if it's, I'm using this type of solenoid and he comes up with a different solenoid that improves the process, but the claims don't address what type of solenoid you use, then he's not an inventor. But if claim 3 is wherein it's this type of solenoid, then he is an inventor. And you can actually, sometimes companies will work together to invent something. And there are times when somebody will run patent A and they will go through and make sure that nothing in patent A is contributed to by the other company. And then you have patent B and the claims are all mixed up. So patent B has inventors from company A and inventors from company B. But patent A is just company A's invention.
Let's get into documentation, Rand. What kinds of documentation tend to matter most when determining inventorship? Lab notebooks, emails, design drafts. There's lots of stuff that go into this.
Yeah, lab notebooks are the best thing if you have them, and emails that address these issues. Some companies are really, really good. They have clear policies. Everything the engineer works on, they write in their lab book. Their lab book gets read and understood and signed off by their supervisor. Those are really nice because I can see who invented what. I can go through and say, Jim and Susan came up with the proper frequency. They came up with all of these things. And then you get other companies. The smaller the company, the more likely this is to happen, where it's just like, there's no documentation. And somebody feels like they invented it and somebody else feels like they invented it. And you just kind of have to figure it out the best you can and go from there. So keeping documentation is a really good idea. It helps to show the inventive process, so who your inventors are. It also can help to show lack of willfulness. If you can show how you created something independently versus, oh, you found our product and you copied it, right? Okay, that looks problematic. That could be willfulness. But if I can go back and show, no, here's the engineer's notebooks, and the engineer says, I've never seen your product before. I deduced this, and then from there I did this experiment and I arrived at that, and that's how I got to where I am. Okay. It's going to be a lot harder to prove willful infringement if that, and then we didn't find out about the patent until you sued us, than if there's no evidence and your product looks a lot like theirs. Because sometimes when they look alike, it's because you're copying. And sometimes people really just do come up with similar things. I've had situations where within a week, I've had 3 people call me about the exact same invention. Totally unrelated people. It just kind of clicked on everybody. And unfortunately, in that case, somebody else had done it a year earlier, and the patent was pending. But sometimes the world just aligns where the idea hits a bunch of people at once.
It's all floating out there.
Yeah,
It's all
it's just
floating out
floating out.
there.
And,
We just
and
haven't
sometimes
been
it's because you're building, that's the next step, right? Somebody had to introduce the cell phone before somebody thought of the iPhone. iPhone wouldn't have made sense before the cell phone was invented.
Rand, we've talked about the inventor team or the list of inventors. What are the legal consequences if a patent is issued with the incorrect list of inventors?
The legal result is the patent's invalid unless it can be corrected, right? And so when they go to correct it, they look at, was somebody intentionally left off? If somebody's intentionally left off, that can invalidate your patent. I mean, if you find the email that says, yes, I know Susan invented this, but I can't stand her, leave her name off the patent. Okay. That's conduct that could either invalidate or render the patent unenforceable. The much more likely scenario is people just didn't realize that Claim 13 was invented by somebody serving an internship in the company who just said, hey, you know what? It would be really cool if we did it this way, right? And nobody thought, hey, that was the intern. And then the intern pops up a few years later and says, yeah, I totally invented that when I worked there. And that can be corrected pretty easily in a procedure like we talked about in the Fortress Iron case, provided that you can find the inventor and get them, serve them so they have the ability to appear and say, yes, I should have been an inventor on that patent.
And then how do inventorship issues intersect with ownership, especially when inventors work with different companies or institutions?
That's when it gets complicated. So an inventor owns 100% right in the patent. Okay, so everybody has the right to the patent, every inventor, and they can license whoever they want. So if you and I have a patent that we're joint inventors on, and there's no assignment to a company, you can go out and license my competitor, which totally defeats the value of the patent for me. So one of the things that you normally want to do is you want to assign the ownership of the patent to an entity that is going to control that. So if we all work for a company, there is likely a duty to assign it anyway. But if we're going to go into business and you say, hey, Rand, let's start this business. We've got this invention that we're filing on. I'm going to insist that we assign it to a company, because the company will have a whole bunch of rules about what happens if we don't get along and we want to dissolve the company. That structure is already built into business law, right? And so the ownership of that patent will likewise be controlled that way. Whereas if it's just you and me and we don't have it assigned to a company and we have a falling out, I can run off and let somebody else license it. And just as you're ready to release your product, lo and behold, much bigger company has the identical product and they don't infringe because they have a license from me. So having an ownership entity is usually a good idea for a patent. If you're an employee and it's related to your work, the company's going to own it, most likely. If it's not related to your work, then there's questions. There's companies that have overarching, anything you invent while you work for us, we own. That's probably not going to be upheld if it's way outside. If you invented a new water dispenser for a dog bowl, and you're a computer scientist at let's say Northrop Grumman, yeah, they're probably most courts are going to say, no, that's outside your scope of employment. That's not reasonable that they own that. But then becomes more of a case by case and state by state issue that you'd look at. Here's what the standards are in this case, and here's how you determine proper ownership. So, but if you're an owner, if you're an employee and your job is to build rockets, the patents related to those rockets are likely to be owned by the company. Now, here's the big caveat, and this is another thing that small companies often run into. If you hire someone as a W-9 or a subcontractor, an independent contractor, you do not get that ownership. So a lot of people will hire somebody to get around tax laws, to keep the cost down. They hire them as an independent contractor. If you're going to do that, you better have a contract with that person that anything that they invent pursuant to that contract is owned by the company. Or what you may have is they're working on a product and they're an inventor on the product, but they don't have a duty to assign the product to you. And now they can go out and assign it to anybody they want, including your competitor. So if you're gonna try and use independent contractors, make sure there's an assignment provision in that contract that assigns the invention back to your company, or you could regret it.
We've covered lots of different areas today, Rand, and here's where I want to wrap this up. Final question. What practical safeguards help prevent inventorship disputes before they become legal problems?
A well-written policy in your company that just explains, here's what it is. Here's how we determine inventorship. Here's how it is. Here's what the reward is. A lot of companies will offer rewards for people who invent things because having people thinking creatively benefits companies, and often it's somebody outside the normal invention chain who comes up with a good idea because they're just looking at it from a different angle. But if you have a well-crafted policy on how you apply that within your company, that resolves a lot of issues. And then you have a policy, if you're working with anybody outside, how are we dealing with this? Are we taking suggestions from our suppliers? Right? Because sometimes those suggestions are going to make their way into the patent claims. And sometimes you're telling your patent attorney, do not claim this, because we don't want, if you claim this part of it, that person becomes an inventor, and we don't want the other company having an ownership interest in our patent.
And the last piece that I would add to it is the documentation. When you said, the notebooks, the emails, all of those things, they seem simple and they're easy to keep. They're already happening. So just make sure they're in a file folder so that you have access.
But when you're going, it's just so easy to let it slide and forget and not do it.
Thank you so much for your time today. That's where we'll leave it for today's episode of Infringe at Your Own Risk. If your company is developing new technology or collaborating with outside engineers, making sure inventorship is handled correctly from the start can prevent costly disputes later. To connect with Rand and his team, visit batemanip.com. And don't forget to leave a review, and subscribe. We'll see you on the next episode.
See you later, Lisa.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.